So our next panel is entitled Traffic Management in Space, Improving Stability with Safe Separation, Trajectories, Communications, and Notification. To moderate this panel, we have Major Melissa Ken. And for those who did not attend her excellent CLE presentation yesterday, Major Ken is an assistant professor of law with the United States Air Force Academy, where she teaches national security law and law for Air Force officers. Over to you, Major Ken.
Well, thank you very much for that introduction, Professor Biller, and the engaging joke to bring us all in. Good afternoon, everybody. We are here today, as Professor Biller said, to talk about traffic management in space. And I'm personally excited to learn from our experts in our panel here. So to give those who are less familiar with the topic just a brief introduction, space traffic management generally involves an organized process to assure the long-term use of space and space assets without harmful interference. And similar to how the growth in air traffic led to air traffic management, the growth potential and development of future space systems has given rise to the need for stability and safe operations in space. So we will hear today from our panelists who will discuss the applicability of the two primary tenets of responsible behavior in space, focusing on maintaining safe separation and safe trajectory, as well as communication and making notifications to enhance the safety and stability of the space domain. So we have our four panelists here today. First, we have Major General Burt, who is the commander of the Combined Force Space Component Command, U.S. Space Command, and the vice commander of Space Operations Command, U.S. Space Force, at Vandenberg Space Force Base. As the commander of U.S. Space Command's Combined Force Space Component, her mission is to plan, integrate, conduct, and assess global space operations to deliver combat-relevant space capabilities to combatant commanders. Dr. Rathnasabapathy is a research engineer. She is joining us virtually, and she is with the Space-Enabled Research Group at the MIT Media Lab. She helps to coordinate projects in collaboration with international development organizations, national governments, and entrepreneurial companies to apply space technology in support of the United Nations Sustainable Development Goals. We have Dr. Weeden here today with us in person, the Director of Program Planning for Secure World Foundation, and he has nearly 2 decades of professional experience in space operations and policy. He directs strategic planning for future year projects, conducts research on space debris, global space situational awareness, and space traffic management. And he also organizes national and international workshops to increase awareness of space security, stability, and sustainability topics. Finally, we have Professor Stevens joining us from Australia virtually, who is the director of the University of Adelaide Research Unit on Military Law and Ethics. He's also a fellow at the Australian Academy of Law, and he is the head of the combined SANT Navy Legal Research Panel, as well as the chair of the SA Red Cross IHL Advisory Committee. And he has spent, in addition to all these experiences, he has spent over 20 years as a permanent officer in the Royal Australian Navy. So a great breadth of experiences here. Looking forward to hearing from our panelists. I'll give you a quick roadmap overview of how the panel is going to go. Each panelist will offer opening remarks following the order in which I introduced them. So we'll start with Major General Burt. I will then ask some initial questions and open to questions from the audience at the end. Before Major General Burt begins with her opening remarks, I want to give the following disclaimer that the views and opinions expressed by the panelists are their own and do not represent an official position of the United States government or the Department of Defense. So with that, General Burt.
Well, good afternoon, and it is great to see all of you in one room talking about a topic that is critically important. So I'm glad we're having this Space Law Conference because, again, all of you are helping us establish those norms and how we operate day in and day out. As the CIFSIC commander, I am responsible for what I would call space traffic management on behalf of the Department of Defense. And then I do space traffic awareness for everyone else. And why I say that is, when you say the word management, it means you have an authority to tell someone to do something. So in the Department of Defense, under General Dickinson's Unified Command Plan mission, we have a responsibility for space traffic management on behalf of the Department of Defense. When it comes to coalition partners, commercial entities, other things, I have a space traffic awareness mission, and that I will tell people that there are 2 objects So a good day is 2 live objects. So then we can tell the 2 owner operators what they would like to do and let them know what we have and decide who's going to move, and we put them in contact with each other. If it's a dead object against a live object, obviously we're talking to the live object to have it do something. The worst days are when it's 2 dead things that are going to run into each other. And as you know, in the past, we've had 2 dead satellites crash into each other and create an orbital debris field. Those are terrible to watch because we know what it does to the domain. But it is a space traffic awareness. I am telling them, our team at 18th Space Control Squadron is telling them about the conjunction or the collision, and they are then making a decision how they would like to proceed. They could look at us and do nothing. And I have no authority to make them do something differently. So this is why it is so critical as we have this conversation today about how do we get to the Office of Space Commerce or Department of Commerce as identified in SPD3 to take on this critical mission of space traffic management. It also would allow us to normalize this warfighting domain to then allow the free and fair use for all to prosper economically and to take on how everyone can operate together. But understand, I will still have a space traffic management role, even when Department of Commerce stands up. Just like if you watch in the air domain, the Federal Aviation Administration manages air traffic, not only in the US, but the international element of it around the globe. But in a wartime situation or an area of responsibility to a geographic combatant commander, you have AWACS, ground radars, other things that manage military air traffic in that warfighting arena. The same would hold true for space. So we get to a normalized domain once we have this civil entity, and if we can start in the US and then work our way out to an international entity, that would be the perfect world for me, because then now I can take those valuable military resources and focus them on space domain awareness, which is foundational intelligence for the domain. And it would also allow us to get after our primary mission, which is space superiority and how we defend the assets that are on orbit today for the nation, and working with hand in hand with our coalition partners. So again, look forward to the conversation today. Just wanted to kind of lay the groundwork of what I do today and where I'm at. And I'm happy to answer questions how we do that, but kind of giving you that space traffic management versus space traffic awareness discussion with authorities, because I'm in a room full of lawyers.
Thank you very much, ma'am. Dr. Rathnasabapathy, if you could go next.
So thank you so much, Major Ken, and hopefully you can all hear me clearly. And before I start, I just want to thank Major Ken as well as the organizers for their flexibility in letting me join remotely. I do wish that I could be there in person, but circumstances changed at the very last minute. Now, I do want to build on the terminology space traffic awareness because I think it is quite poignant at the moment. And if we think about just the past decade of the space industry, we've seen a growth of space actors as well as commercial space activities. We've seen lower satellite development and launch costs, and frankly, a growing global space economy, all of which are in stark contrast to the pace of the development of regulatory guidelines and norms of behavior surrounding long-term sustainable and responsible use of the space environment. Now, there are, of course, 2 sides of the coin with this conversation. On one hand, as we see the number of stakeholders involved in the regulatory processes increase, it's crucial to be inclusive. So we talk about an international space traffic management mechanism or system. So we want to ensure that there's wide adoption of standards as well as well-defined norms of behavior. But on the other side of the coin, there's technical advancements that are emerging at a very critical moment in international relations. And finding consensus-derived technical as well as safety standards is often quite a slow process. And efforts to manage and govern these risks and challenges are really becoming quite increasingly complicated. So there certainly is a growing need for both technical space traffic management systems and space traffic awareness systems but also the policy regimes to coordinate activities. And in the last panel, just before the lunch break, we heard that there's a need to know where, what, how close, but also the risks associated with it. So at the Space Enabled Research Group at MIT, we considered the designs of systems that would yield a more equitable, but also a just access to and the use of the space domain. So in this conversation, I want to highlight some of the work of our researchers and myself at Space Enabled, and then also answer some questions on what we're doing regarding SSA, detection, identification, tracking, and happy to go into the nitty-gritty of that work.
Fantastic. Dr. Weeden, please.
Thank you for that. Thank you for the introduction. Thank you for the invitation to be here. I think I'm going to use my open remarks to kind of give a political history of space traffic management in the U.S., just to recap what's happening. But first, I just want to say this is an issue very near and dear to my heart. So if I get a little worked up about it at some point, I apologize in advance. My last job in the Air Force was an orbital analyst working in the 1st Space Control Squadron, which is the predecessor to the 18th, down here in Cheyenne Mountain, doing exactly what General Burt mentioned. And then I got out in 2007, and since then I've been working on this from a public policy perspective, and been interesting to see how it's evolved over time. So let's turn back the clock 12 years ago, because the US government has been working on this formally for 12 years. It is the summer of 2010. The Obama administration just unveiled it's June of 2010 specifically, they've just unveiled their new national space policy, which focuses quite a bit on exactly what General Burt talked about how the changing nature of the space domain. We need to have more of a focus on the long-term sustainability, safety of space operations, being able to determine, potential threats, all those sorts of things. One of the implementing actions was fixed space traffic management. So a couple months later, they started the first interagency working group working on this issue of space traffic management. And of course, they went through everything from what do we call it? Is it management? Is it coordination? Is it control? That whole discussion, the things that normally happen in an interagency discussion with all the different departments and agencies and all the different equities going through. They had that interagency group meeting for the better part of the remaining 6 years of the Obama administration. And they laid a lot of the groundwork for the terms, the definitions, the approach, but they could not settle on this one issue of who in the US government would have this oversight authority for space traffic. They were leaning towards the Department of Transportation and would house it within the Office of Space Transportation in the FAA, but had not made a formal decision on that. There's a change of administrations, the Trump administration comes in, and relatively early on, so the end of 2017, they made a decision to revisit this process. They started up their own interagency working group. And to their credit, they built upon a lot of the work that had been done by the Obama administration on laying the groundwork and the definitions and sort of the way to approach this. The big difference, of course, is when the decision came out, and this is Space Policy Directive 3 that General Burt mentioned, issued in June of 2018, they gave this new authority to the Department of Commerce, which is a big significant difference we can talk about a little bit more later. But in general, Space Policy Directive 3, which is the first US policy on this issue, lays out roles, definitions, all kinds of useful things you see in national policy, and does two major changes to the existing system. One would be to move the safety-related aspect of what the US military has been doing for a long time to a civil agency, i.e. the Department of Commerce. Two would give them a degree of authority over private sector space activities to be able to do that management oversight function, implementing the Article 6 requirements of the US government. And why that was important is there were some agencies already doing that, NOAA, the FAA, and the FCC, but each of them was doing that licensing for a specific type of space activity. NOAA was doing it for commercial remote sensing, the FAA is doing it for commercial launch, and the FCC is doing it for commercial use of the radio frequency spectrum. There's a whole host of commercial activities coming down the pipeline that don't fit neatly into those buckets. And so they felt rightly there was a need to have some agency that kind of filled in that gap and could kind of give a general, say yes to a whole bunch of new commercial stuff while ensuring those companies were complying with the international principles that the US government is meant to uphold, as well as US law. So the policy is issued, right? We're done. Great, let's all go home. Well, of course, you have to have the policy being implemented. And that's where we still sit today. 3.5 years later, significant portions of that presidential policy directive have not yet been implemented. We do have the Department of Commerce working on a civil equivalent, or not equivalent, a civil version of a database of objects and things in orbit that could be used to provide warning and other kinds of basic services. But that work just started very recently because Congress did not give them the funding to do that until December of 2020, right? Because the executive branch can make policy, but Congress controls the budget, they control the purse strings, and they also control new authorities. And Congress has not yet acted on giving the Department of Commerce or anyone else new authorities to oversee private sector space activities. And there's a whole other debate as to whether or not you actually need those authorities. Can you make what exists work? We can get into that a little bit if you'd like, but that's where we stand now. We have this policy that is generally, bipartisan and is what's been worked on across 2 administrations. We have an agency that's been identified. We have them starting work on a civil database that can provide some basic services. But there's a lot of open questions about about how to build in all the rest of the pieces. And it's, 12 years since we started this process. So I'll stop there, sort of an introduction of what's going on. I'm happy in the discussion to get more into what's going on other countries, internationally, lots of other aspects of this.
For that, sir. Professor Stevens.
Thank you very much, Major Ken, and thank you for inviting me to present at this conference. I'm coming to you from Australia, which means I'm coming to you from tomorrow. It's actually 5:20 a.m. tomorrow your time, and so excuse my bleary eyes if you see them. Look, I'm a lawyer. I've been given 3 to 5 minutes. Of course, I'm going to take 5 minutes. I'm going to take the maximum time to speak. So let me do that. Issues of collision avoidance, construing intention in areas beyond national jurisdiction, indirect ways and direct ways in trying to deal with this. Soft law is one way moving forward. Long-term sustainability guidelines, interagency, space debris coordination committees, international telecommunication union guidelines, etc. Problems of open language, lack of specificity, and no legal obligation. So there's hard law. There's the OST, the Outer Space Treaty, and you've got articles there that can assist. Article 9 in particular. But you've got states reluctant to rely on the law, reluctant to invoke the OST. So it's hard to understand legal thresholds. So then the question becomes one of intention. What does it mean? What is this state doing? Why are they doing this in space? And we've got recent examples, the Luch incident, the Cosmos 2543. We have the French government saying that what the Russian satellite was doing was espionage. We have the US commander of the Space Command saying after the 2543 incident, there needs to be a discussion on norms of behavior and in space. We all agree on that. And then, of course, last year we had the Chinese note verbal about Starlink and American responses saying you could have spoken to us, but you didn't. That causes issues. So what's the way forward? The OST, of course, Articles 9, dealing with state consultation for activities that potentially cause harmful interference, actions of due regard. What does due regard mean as a matter of law? And then finally, Article 11, which deals with informing parties about activities that, to the greatest extent feasible, about activities that relate to engagement. What do I suggest as an answer? And I think I'm frozen on the screen from where I can look. Am I? Oh no, I'm back. I'm back. Sorry, I'm back. Where can we go? As Major Ken said, I have a Navy background, and one of the things that has developed in the naval context, which is also an area beyond national jurisdiction, is the Convention on the International Regulation for Preventing Collisions, COLREGs, which have rules of the road. The Law of the Sea Convention has traffic separation schemes, has safety zones, etc. Is this a potential way forward? My feeling is that it is, and there are opportunities to rely for states, state space agencies, civil society, or militaries themselves to engage with each other to talk about what possible mechanisms might apply for construing intention and for avoiding collision. I draw your attention to something called CUES, the Code for Unalerted Encounters at Sea. It grew up at the Western Pacific Naval Symposium. It's a voluntary set of non-binding rules comprising safety procedures, communication procedures, and basic maneuvering instructions. This has had impact in naval operations, certainly in the Pacific and in the Indian Oceans. It deals with activities that states themselves or militaries themselves have agreed cause concern. Simulation of attacks, aiming weapons, discharging weapons in the direction of other ships, laser marking of bridges, aerobatics in the vicinity of ships. These are areas that have been identified between militaries as causing concern and something you ought not do. There is Navy-to-Navy talks between USA and China, and even USA and Russia, and I think that mode of engagement is a way forward in terms of identifying with specificity issues that need to be addressed with particular reference to space. We can talk about military diplomacy and its advantages and disadvantages. We can talk about soft power, but I think the West particularly needs to be clear in its own mind as to what is threatening behaviour, what is a use of force, and there needs to be articulated specificity. And I know you've heard from Professor Jack Burt, who has spoken about the WUMRA manual, and of course that is the answer to everything. And we can talk about that later if time permits. I've probably used up my 5 minutes, so I'll hand over to Major Ken.
Thank you very much, sir. All right, so with that, we'll move on to some opening questions, starting with a question directed towards Professor Stevens, who I'll ask to respond first, and then Dr. Weeden. There are several existing structures which govern and attempt to regulate space traffic management and responsible behavior in space. We've already discussed a few of them in your opening remarks, including the Outer Space Treaty and new EU policies and things that are coming from the United Nations. Do these policies and agreements have the ability, specifically the Outer Space Treaty, have the ability to adapt to new practices in space? And are these structures sufficient to protect space traffic management and ensure responsible behavior in outer space? So Professor Stevens, I'll ask you to take that one first.
Thank you. Thank you very much, Melissa. Look, my answer is that yes, I do believe the Outer Space Treaty has within it the framework and the architecture to permit engagement on these key issues. The key, I think, is to identify what is legally, what are the legal thresholds, and states make international law. So states can determine what those thresholds are. The challenge is to identify them and to have agreement, and then move forward. I understand the role of soft law. I understand how these codes of practice and guidelines can help shape thinking, but there's always an out. They're non-legally binding. Their language is generally open, and I think that, in my view, there is a capacity for states and particularly military to military engagement to provide a foundation of understanding, to create levels of trust over at least thresholds that have been identified, and then to act accordingly. And over time, this can turn into law. It's the matter of the Vienna Convention on the Law of Treaties, Article 31, 3b, and also customary international law. So I do think there's scope. I do think the OST provides the architecture, and I do think there's hope for the future.
I'll echo that, and I'll frame it as, I'll say the Outer Space Treaty is definitely necessary, but not quite sufficient for what we need, in the fact that it is very broad, right? As we talked about the last couple of days, the legal principles in the Outer Space Treaty are extremely broad, and there's not a lot of work that's been done to sort of talk about how do they actually apply, how do we implement them. So I think that's sort of where the question is on space traffic management. I'll say that, you know, there's an ongoing debate, sort of philosophical question of what comes first. Do we first have an agreement on the international norms, standards, rules of behavior that make up space traffic management, and then we implement them at the national level? Or do we first put in place the national level regulatory bodies and authorities, and then have the international debate? Space Policy Directive 3, as I outlined from the United States government position, is more in the latter, in that it basically says we're going to put the national level stuff in first and then engage international discussions. My answer to that question is we need both at the same time, unfortunately, because, you know, it's if you do manage to have the international discussion, that's going to take quite a while, and then when it's done, it's not all that useful unless you now have all these national administrations that can implement through national regulatory regimes and licensing regimes, whatever rules and standards that are agreed to internationally. At the same time, if you put all the hard work in developing the national regimes, well, what is it they're going to put in their standards, right? What is it they're going to require people to do? Well, that, you know, if each country does that individually, now you end up in a fragmentation regime where maybe the US and the UK and France and Japan and Russia and China all have slightly different, maybe even seriously different traffic standards that all their private sector entities are required to do, and now you've got kind of chaos. So you're going to have to do both. And yes, that is going to be difficult, and yes, that's going to take a long time. But I think you have to do both. It's not a question of either or a question of what comes first. I think you have to work both at the same time.
Thank you very much. So for our second question, I'd like to direct this to Major General Burt and Dr. Rathnasabapathy. As previously discussed, communication and notification to enhance safety and stability of the space domain is one of the 5 tenets of responsible behavior in space. How do we accomplish transparency in communication when it comes to conjunctions and revealing space situational awareness data? And General Burt, I'd like to start with you.
No, that's a great question. And it kind of leads from the previous discussion, right? I think we are doing that in the DoD every day, working both elements of this, of how do we work with our international partners. We also have I have a commercial integration cell on my ops floor of 10 companies who spend a lot of time talking to us about what industry would like to see. And one of those is SpaceX with Starlink and a proliferated LEO constellation. They've now put out that they would like to have 25,000 that they've registered with the FCC on orbit satellites. It's a lot of satellites in low Earth orbit. So again, I think we are talking at different levels and trying to build those norms of behavior with each other. From a transparency perspective and communication, our organization, if you have not seen spacetrack.org, it's out there for everyone, and that is how we publish space traffic management data on everything that is on orbit today at the unclassified level. You can, if you are an owner operator of a satellite or you have a concern as another nation or commercial entity, you can get an account to that and go into it. I would ask you not to all go get accounts just for fun, because it does bog down the website. We've continued to keep trying to improve the bandwidth of the website. But I can tell you last November when we had the Russian ASAT, we magically had 2,000 new users in one day. that wanted to look at the space debris patterns. And again, in low Earth orbit, we are still tracking about 1,600 pieces of debris from that event. So you can see why it's important to be transparent and understand and show the space picture, if you will, to all the folks who want to operate free and fair in the domain and safely. So there's a safety of flight when you launch things and how you operate. So that communication is important. As I mentioned to you earlier, when we know of a known collision between a live object and another live object or a piece of debris, that notification is made directly to those owner operators, and we have a whole Rolodex of those phone numbers. Interestingly enough, when that happens with China or with the Chinese space station, we make notifications we have an email address and a place we call for the Chinese. They don't always respond, they don't answer. We don't know if they take that information and what they do with it, but there is no channel. In their defense, and I know that sounds unusual, a space operator defending the Chinese, but in their defense, if the Chinese military called me and told me to do something, I don't know if I would do it either. Which again gets back to this discussion of making sure that we have a commercial entity or a civil entity that's doing this. But those communications happen every day. The other things I would say from a larger international perspective, you guys may have heard of the Combined Space Operation Initiative, CSPO. That is 7 partners working together. So the United States, UK, Canada, Australia, Japan, New Zealand, and Germany, and France. I hope I said them all. I'm probably not doing the math in public. But all of those nations just signed in February of 22 of this year, the new CSPO 2031 vision. And what we would like to see moving forward is those norms of behavior and how do we develop those together. The UK is leading in the UN as the CSPO partner lead on what are those norms of behavior we would like to see across the board and how does each nation get on board. I think it's interesting when we talk about the law of the seas, for example, the US is not a signatory of the law of the seas, but yet we follow it every day customarily, but we are not a signatory. So I think, again, this discussion of statutory law, customary law, how do you build those norms of behaviors and are transparent in the communication of what those are very important. The one thing I would challenge in these discussions that we're having to this point in communications where I think we are missing a lot and we are affecting our economies around the world are the industry, the commercial and industry side of the business. So I'll give you the launch example. No one would have thought in our business about returning rockets to the launch pad. Our risk tolerance in the government, in the military for space launch was very different than what Mr. Musk pursued and what business will pursue, because again, it's about dollars, it's about risk, and it's about what a different set of criteria and agenda, right? So how do we, if we look at space traffic management and transparency and how do you communicate, how does that get done in the commercial market? They may look at that differently than we do. How do we get that civil commercial voice into that discussion? So again, this has been largely a government and a coalition discussion. We've started partnering with Department of Commerce for them to stand up, and we look forward to their successful stand up. But largely this has been a government-led, DoD-led initiative. And why? Because we have been the primary operators in the domain until the last 5 to 10 years. And so that is shifting. And so how do you create those opportunities to talk and have that transparency and communicate? But we are communicating with anyone who will listen to us every day. That's our job to do on behalf of the nation and working with our partners. But again, I go back to that, what is my authority to tell someone to move or to work that safety issue? And if they ignore us, so what? Who is going to hold them accountable? What laws or rules are there if they're outside of the Department of Defense to hold them accountable? So we want to be transparent. We're communicating all we can is what I would say bottom line. And there are a lot of opportunities both with our coalition and military to militaries going on. I think we've got to get that vital civil commercial voice more involved in the conversation because I think they may look at the challenges differently.
Thank you, ma'am. Dr. Rathnasabapathy, could you please provide your comments?
Thank you. And I know that my surname is incredibly difficult, so I appreciate you taking the effort to pronounce it. I think this is such a poignant question. And as the space environment becomes increasingly complex, there certainly is a need for more timely, but also more accurate data sharing practices between actors. And this was actually noted in the 2021 study. It was called the Space Sustainability Stakeholder Engagement Study that was published by the United Nations Office of Outer Space Affairs. SPACE has terrible acronyms, but I'm talking to the converted here. I think you all know that. But transparency and information sharing were highlighted and were identified as the critical elements to gain trust and build confidence amongst the space communities, especially with the numerous stakeholders. So talking about government as well as the private side. Now, on a more tangible note, I want to talk about a project that we've been working on here at MIT. So over the past 3 years, our team have been working with the international consortium to find an innovative way to address this orbital challenge by incentivizing the industry to firstly design missions that are compatible with sustainable and responsible operations, but also operate missions in compliance with international policies and standards that continue to consider the potential harm both to the orbital environment, but also the harm potentially on other operators and collisions amongst objects. So we call this project the Space Sustainability Rating, or SSR, and it's essentially a rating system to assess how sustainable a space mission is in every stage of the mission's life. And in its very first edition of the SSR, it's made up of a couple of different modules, including data sharing, collision avoidance, standards and regulations, as well as detection, identification, and trackability. So I wanted to deep dive just into 2 of the modules. And let's take the SSR's data sharing module to start off with. And essentially that is to reward actors who are open to sharing data about their missions, and includes questions around collision avoidance, coordination information, satellite metric information, as well as satellite characterization information. But it also considers the audience with which the space operators are sharing this data with. So is it SSA providers who operate a SSA database? Do they provide this upon request for other operators for coordination in response to a high interest event? Is it to a voluntary network, or is it even to public sharing? So depending on the data sharing practices as well as the audience, the space operator will score certain points for it, which will take them to a certain level of the SSR rating. Another example is the detection, identification, and tracking module, which considers the level of availability for observers to essentially detect, identify, and track the mission. So the SSR evaluates these aspects of the mission using a software model that simulates the reference ground station network with both optical as well as radar sensors to calculate the probability that a given mission can be detected. On the identification side, it's the probability that an observer can identify that object as one of the objects in a known catalog, really using the information that is independently measured. And then on the tracking side, we think about the probability of an observer that can effectively predict when an identified object will return to the field of regard of a network of sensors based again on the information that's independently measured. So We talked about hard law and soft law. We talked about the technologies that are really advancing the fact that there are so many new actors in space. So what we do is we want to envision the SSR essentially as a bridge to connect the two. So ensuring that it's keeping up to date and it's rewarding and recognizing actors as they take on these different technologies, but also having an avenue to ensure that the laws and the policies, the norms of behaviors are keeping up to date with these technology and innovation, I guess, progressions. So in that way, the SSR allows for actors to present a single point of reference that can be assessed and demonstrates their mission's level of sustainability. And by making this aggregate score publicly available, it increases the transparency, but also without disclosing any mission-specific sensitivity or proprietary information, which is some of the key concerns when it comes to data sharing and transparency.
Thank you so much, ma'am. And before we move on to questions from the audience, I just wanted to give a brief opportunity for any panelists to discuss current scholarship that they're engaged in. Professor Stevens, I know you expressed an interest in this, so I'll turn it over to you first, and then any other panelists can jump in after he's concluded.
Thank you, Melissa. Yes, as I foreshadowed, I'm actually chair of the governance board of the Woomera Manual, and as I mentioned, you've heard from Professor Jack Beard, who is the editor-in-chief of that manual. That manual we've been working on it for 4 years, and we have just finished a draft of a complete final draft of what we think the law is based on what state practice has been and what state statements and non-actions have been, and they have legal significance too. And that just for, thank you, Melissa. I'm going to take this as a bit of an opportunity to plug this. We've given it to the Dutch government, who's distributed it to states around the world to have a look at, with view to having a state engagement process in June in The Hague. And I do know that the United States has a copy, and I look forward to hearing the US's views on what we got right, and even what we got wrong. And because it's a draft, if we've got something wrong, and the Americans and any country says that's also very helpful because we'll get it right. And so that we're hoping that will help provide a reference point that's commonly agreed as to what the law is for the sake of future behaviour.
Okay, and with that, I think we'll turn it over to questions from the audience, both in person and virtual.
Good afternoon. Thank you all so much. We do have one question from so far from the virtual environment. This is from Mr. Mark Meyer. He asks if it might be possible for us to build an intergovernmental space traffic administration for civil and private objects in space, so as to have kind of a space traffic management starting point.
I'll start on that just because my organization, we're observers to the UN Committee on Peace Outer Space, and I've been, sitting in the back of the room for some of those discussions. That's a very large lift to get there, because it deals with an issue we came up earlier, which is sovereignty, right? You're talking about something that would have some sort of level of sovereignty over activities that's really difficult to get to at the moment. States on the Outer Space Treaty are responsible for the activities of their private sector activities, and it's up to them to do that. There have been some discussions, proposals for a multinational / UN situation awareness system. The Russians have been primarily the ones pushing that. Maybe I'll echo Jack's comment from earlier about maybe not going with what the Russians put in their first draft as a starting point. But even no matter who put that forward, you now have the question of who at the UN level has the capacity or the ability to do this. How do you fund it? what is the rights and obligations between those and the nation states? Is it just whatever data they want the states choose to put in there? Even that is really difficult to get into. I think where things are probably headed is something similar to maybe the ICAO model, although maybe not an actual international body like ICAO, but something where states have some sort of agreement on what the international standards are for traffic in space, that is then administered and implemented at the national level. That's sort of the way I see things going. Certainly things might change, but creating a supranational body that kind of does that regulation directly, that's a very, very big political lift.
I'd like to build on what Brian's comments as well, if I may. So like Brian, I've also been at the back of the UN COPUS meeting room, just really watching. And it's been so interesting because, more and more there've been increasing number of delegations joining COPUS. And so finding consensus, as I said in my opening remarks, have been really difficult and more challenging. I want to highlight the work of one of our master's thesis students, Miles Lifson at the Space Enabled Research Group. Miles is currently pursuing his PhD in aeroastro, but he conducted an analysis of the current proposed STM architectures and he did a series of interviews to highlight what some of the gaps in the understandings were. And particularly from the perspective of emerging space nations and commercial actors, both their attitudes on data sharing as well as the concerns of the level of specificity that are needed. And the research shows that the efforts by self-interested actors who really stand to gain the most from STM capabilities, at least in the short term, could likely lead to the development of STM systems, but these systems would not necessarily reflect the interests of all space actors. And essentially in a bottom-up approach, they could exclude those who lack capacity. So when we're talking about these intergovernmental mechanisms of systems, or really trying to establish an internationalized STM system development, I think taking into consideration all of the actors equally, both government as well as commercial, regardless of whether they've been doing space for the past, couple of decades, or whether they're launching their very first satellite, is absolutely crucial in pushing this conversation forward.
Got a question, primarily for Professor Stevens, but for any of you possibly. A number of references have been made to the International Convention on the Law of the Sea, which was a treaty that had a lot of disagreement during the formation period. However, after it was implemented, states quickly came on board with most of the provisions fairly rapidly, to the point where it became primarily customary international law in a very short period of time. Obviously, there's still a lot of disagreements about drawing baselines and et cetera. But for the most part, most states quickly adopted the provisions and accepted them. I'm wondering if there's anything that can be learned. Was there something about that particular treaty, the formation process, the implementation, that could be learned and then transferred into the space traffic management environment?
Thank you. Let me respond to that. I think that's a terrific question, and you're right. The United States is not a party, as Major General Burt mentioned, is not a party to the Law of the Sea Convention. But Ronald Reagan in 1983 said that the navigational parts of that treaty represent customary international law as far as the United States was concerned. And so it's one of those interesting phenomenons where you have a non-state party, being the United States, that in any conference that I go to on the law of the sea, the US stands up and quotes it to the comma and to the full stop of the treaty because it represents a customary international law. And those of us that are parties to it tend to be more ambiguous in our interpretation of that treaty. But nonetheless, I think it has stood the test of time because it's very practical. Parts of it are very, very practical. And I take Minoo's comment earlier about self-interest and how that can guide certain approaches. And I think what you find in the Law of the Sea Convention is that the self-interest in the Law of the Sea Convention, to some extent, at least when it comes to things like potential collisions, is that everybody wants to avoid their ships colliding on the high seas. And so there's a practicality there that that sort of transcends formal legal positions. And I think that does provide a useful starting point in terms of, when I say starting point, a reference point. I think what's happened with the Law of the Sea Convention, and I know there are some space lawyers who react very negatively to referring to the Law of the Sea Convention and the Outer Space Treaty. They get very agitated and they start frothing at the mouth. But it does deal with areas beyond national jurisdiction, which is what space law does as well. And so I do think it does have a useful foundation for where we might want to go in terms of space.
So if I could pick up on those 2 points. One, I think this ties back to the whole discussion we had this morning about you know, the challenge, I'll say, the United States has with signing up to new legally binding agreements, right? We haven't really done that since the 1980s. UNCLOS is an example of that. There's, you know, a couple of space examples of that. There's also the Trans-Pacific Partnership, a trade agreement. We just, you know, the domestic US politics that make it very difficult for the US to agree to new multilateral agreements, even if major US entities like the Department of Defense or NASA or whatever think they're a good idea and think we should apply them operationally. That is a challenge we're going to have to address ourselves when it comes to things like space traffic management, where we kind of want there to be a rules-based order, but we have political challenges there. But to the point that Dale just raised there, you know, I mentioned ICAO, which is the air law model. There is this debate about what is the better model. Is it ICAO in the air world? Is it the UNCLOS in the naval world? I kind of tend to lean more towards the maritime world because that is a model where the vast majority of the activities in the domain is outside any one state's sovereign control, which is kind of the way space is, right? But to the point that that Dale just mentioned, I think one of the reasons there is kind of this aversion to doing that is because of this term global commons, which I don't think we've talked about so far here today, which generates significant, you know, shuddering from certain people of a philosophical bent. And in fact, the Trump administration issued an executive order declaring space is not a global commons. So if that's the case, then how can you apply a global commons kind of a framework, which is my layman's interpretation of the Law of the Sea Convention, to space? This is one of the questions. Of course, the real answer is neither of those regimes is truly the mirror image of space. We might borrow from both, but this is sort of at the philosophical level. There is this debate: should we look to maritime or should we look to air for sort of the underpinnings of a space traffic management regime?
Chime in as the DoD guy. So I think everyone may or may not know, last summer, Secretary Austin signed the Responsible Behaviors in Space for the Department of Defense. And you might say, well, why would the DoD put out a document like that from the SecDef? What's the value there? Well, I tell many of my folks when we talk about the domain itself, it started in the government, and we have been operating in it as the Department of Defense longer than anyone else other than NASA, working with us side by side, right? And so the government had a responsibility to say, here's how we've been doing it for these many years and doing pretty good in a peacetime domain, and what we found to be true. You don't want long-lived debris. You want to be transparent. You want to have open communications. You want to operate your satellite day in and day out operation responsibly within a slot or block that you have been given. How do you communicate when you lose your satellite? You don't leave a satellite on orbit bingo fuel without any gas to be able to dispose of it. You know, all these things that we've done my entire 30-year career as a satellite operator. are just norms for us because that's how we do business. And so we felt putting it on paper and saying that out loud to the community was a way to get it out there. And again, are there others? Are there different things we should look at? Absolutely. But we owed that to the community because again, this domain started in the government and now we have seen the growth on the economic side in commercial and industry. And that may change that whole regime, but at least we should put on paper how we do it today or how we've been doing it over these years. And so I think those rules and norms resonate. We have a lot of like-minded nations, as I said, with CSPO that feel similarly. We agree to disagree, as we've all talked about, on certain points and details. But I think on the whole, we recognize being transparent and communicating with each other is important. So space situational awareness sharing agreements, we talked about data sharing. In the 18th Space Control Squadron, through what was US STRATCOM that started in 2011, and to today with US Space Command, we have 29 international DoD sharing agreements where we are sharing space situational awareness data with each other. Here's where my satellites are, here's where your satellites are, and we are sharing that information. And again, that goes back to the spacetrack.org, how we are putting that online and allowing them all to have access to that data. So I think it is important. We've built some building blocks. I'm not saying they're the final answer by any stretch, but I think we have been slowly but surely building, at least within the Department of Defense and with our military coalition partners, how we would look to do that.
Doug Legore, Rand Corporation. Great panel. Thanks to all of you. I'm going to ask a slightly scientific question, and as a lawyer, I'm probably going to get the science wrong, so forgive me if I do. But I've read that, sensors will only tell you where something is in space. They won't tell you where it's going. In order to figure out where it's going, you need an algorithm, and everybody has their algorithms. And my question is, so how would we adjudicate which algorithm or data is appropriate to make a call, to make a final call? And is there one algorithm to rule them all? Will that ever happen?
I'll answer, it's a fascinating question, right? It gets sort of the heart of this. If we're gonna have rules about too close, how close is too close, or are you in the right spot or not, we kind of have to be able to tell whether people are in the right spot or not. So a friend of mine, Dr. Rita Bajah, who's a scientist, astronomist, is working on this issue. He answers this by saying, well, how do we know what time it is? We have 200 clocks, right? And we compare them all to each other, and that's how we know what time it is. And what he's getting at there is, for the moment, we don't have a universal, agreed, accurate representation of where things are. We have multiple opinions, right? We have, this is where the satellite operator says it is. This is where the commercial company Leolab says it is. This is where the 18th Space Control Squadron says it is. This is where maybe the European EUSST program says it is. And then we compare them, and maybe they all agree. Maybe they don't, because they have different weights and biases, or they're using a different propagator, or they have a different way of estimating atmospheric density. And I think this was really interesting example of this. A year and a half or 2 years ago, there was an incident where Starlink and OneWeb had a couple, there was OneLink satellites going up through a Starlink constellation, and they had a public spat about who's going to move and too close and whatever. And SpaceX submitted a document to the FCC that had the conjunction assessment for 4 different entities: the 18th, Leolabs, OneWeb, and Starlink, and they were all different, right? So who was right? I mean, in the end, there was not a conjunction because one of them moved. So we don't really know if there would have been or would not have been. But I think that's a perfect example of the state of the art where we are today. I would submit no one has the right answer. And we're going to get there by having multiple opinions about where stuff is and comparing that. Now, maybe in the future, we get to, a better way to do that. But the minute you start propagating trajectories into the future, all sorts of uncertainties come into play. Let's close. The other example is space weather, right? So there was an incident a little while ago where Starlink launched a bunch of satellites into a very low perigee orbit, because that's what they do. They launch them into a low orbit so that if any of them are dead on arrival, they fall out of the atmosphere really fast, and then they raised them up to the operational orbit. Well, shortly after they got placed into orbit, there was a severe space weather event, which changed the atmospheric density. And that whole group of, I think it was 20 or 30 satellites, 32, just fell out of orbit because they didn't have enough time to raise up, right? I mean, there were some people, well, you might have been able to predict that because we do have 12 hours or so of warning, but you know, that's an example of how hard it can be to kind of predict where things might be in the future because the space environment is changing. There's space weather. It's kind of crazy.
So I'm going to show a little hubris here. I have the best. No, I'm kidding. But what I will tell you, so that example, those examples are great, and that the 18th Space Control Squadron, we have a rep with SpaceX on our ops floor working Starlink issues with us as a commercial partner because of proliferated LEO and being able to work these conjunctions. So again, they use GPS trackers on their satellites, GPS receivers on the satellite, so they can tell you pretty accurately because of GPS where they are in the sky. That information is provided to us and we are going back and forth in comparing information. One thing I haven't heard anyone talk about is in other domains, you have transponders and you have things that beacon to say, I am a good guy or I am this. And that is then given down and received, and it doesn't have to be tracked. I don't have to put my critical resource radar energy on those things because they're telling me exactly where they are. As an operator of a GPS, I was a GPS squadron commander. Again, where we knew those satellites were and sharing those element sets, we knew exactly in the sky where every one of our satellites were because we were talking to them 2 and 3 times a day. So how do you bring all of that data together in a way, as we talked about, that everyone is comfortable with and has a self-interest to do to avoid those collisions? So I'll go to the SpaceX example. Launch 40, 32 they lose. When we launch 40 satellites off of Starlink, they do launch into that lower Earth orbit because again, that was intended to be a safety of flight before they then orbit raise. Well, what happens when they hit this solar maximum that they saw with the intensity increasing, they had done that a couple of weeks prior without incident. So again, from a business perspective, you're like, that's an acceptable risk. I already did that once and it didn't affect me. So they knew the space weather, we had given it to them. It was, well, we've done that before and we didn't have any consequences. So we're going to press with the launch. And they did. Now, who did they call when they couldn't now find the satellite? Because now I recognize when they open their eyes and look for the satellite, they're looking for the satellite based on the models that says how they come off of the launch vehicle. So when they looked up, the satellites were not where they were supposed to be. And so now they're scrambling to find them all. And so now they're calling us and we're having, because we have an SSA sharing agreement with them, we are working through how do we help them find their satellites. And again, before we could get all of them rallied, they were able to save 8, but 32 others did not make it. So we learned a lot from that. I think they learned a lot from that. And again, how they will go now forward as they look at solar weather, they will take that probably into their calculus a little bit different. But what I love about that company is they lost 32 satellites and a week later they launched 50 more. Didn't blink an eye. They fail fast. They just keep moving. And when you have thousands of satellites on orbit, 32 is a drop in the bucket, right? So I think that's the value of how do we work together and talk and share. And this happens in every other domain. You know, when there's an in-flight emergency or somebody has an issue, there is a process and a way in other domains to address those and help each other. It's not like, oh, I hope you crash and have a great day. I mean, there's elements that come together to help, to include the military, right? Whether it be the Coast Guard, the military in general. If we had radar coverage of something and something was at risk, we would work those things together. So I think the space domain is no different. But it's, again, how do we keep working the data sharing and at an accuracy that we think is good enough? General Raymond says a lot of buy what we can, build what we must. I think in the space domain awareness or the space situational awareness, space traffic management business, there are companies out there trying to build their capability. Is it perfect? Have they been doing it as long as us? No. Are they getting better? And in partnering, can we help each other both get better because they look at the problem a little differently than the Department of Defense? Could we team to get better? I think that's why it's so important that commerce comes online, because I think then you're going to see a rapid growth of what is the standard and how do we get better together, because we all care about operating safely in the domain day in and day out.
Just quickly to that point, 2012, I wrote something called Going Blind, arguing why that safety SSA mission should go to a non-DoD entity. One of the reasons was my frustration with the pace of technological change in the Department of Defense, which is something we've all talked about, right? When, I mentioned I was on crew in Giant Mountain, we learned how to use a system called SPADOC and CaveNet in 2004 that was supposed to go away in 2005, and they're still around today being used for key parts of this mission. And to reinforce General Burt's point, that is one of the big reasons why some of us thought there should be sort of another player in the game. The military is going to need to do their mission for the national security reasons. There's this other piece, very rapidly changing piece, which is the commercial safety mission that's going to have to leverage this rapidly changing technology. That's very difficult for the DoD to do. And so that was the hope. We still hope that is where Department of Commerce can go. But as I mentioned, it's not just as easy as issuing a policy directive and therefore everything happens. There's a whole lot of other pieces to that still need to be worked out.
Hi, Professor Stevens. This is Seth Dilworth. I have a question for you and then for the rest of the panel as well. Professor Biller framed a great question earlier about the comparison to the law of the sea and the development of customary international law. And we've talked a lot this week about the pros and cons of responsible behaviors in outer space. On this particular topic, do you see a benefit in advancing an agreement, even though we may not get full consensus on that agreement, to develop customary international law rather than taking a soft law approach? And then for the rest of the panel, if so, is in your work with allies and partners in particular, would they be receptive to that? Thanks.
Thank you, Seth. And for what it's worth, Seth wrote a great master's dissertation at the University of Nebraska. So let me publicize that. I had the great fortune of reading that. Look, as to strategy, what is the best way? Soft law, emerging customary international law, hard law treaties. In some respects, all of the above. I want to make reference to General Burt's comment about the memo, the tenets of responsible behavior in space. I think that was a great initiative, a great public statement by the United States that does help. And I think it does mean that what it does provide is a foundation point where states and entities can rally around to say, what does due regard mean? What does harmful interference mean? And what does avoidance mean? What does safe separation and safe trajectory mean? And how do we give that greater specificity? How you do that, in my view, is I made reference to this thing called CUES, the Code for Unalerted Encounters at Sea. This was just a military initiative. Navies were talking to other navies about what do we do, what ought to be the standards. And it began as just an agreement that had specificity. And it's still not law, but it's observed. And it's observed because it makes sense. My view is using perhaps the responsible behaviours in space memo as a foundation, giving that specificity, coming to agreement at least with Western and nations and allies to get a consensus, and then with that consensus move forward in terms of statements about customary international law, and who knows, perhaps even a new treaty. But I wouldn't be holding my breath about that anytime soon. But you don't need that. You can still have binding obligations in terms of the existing treaty, the OST. I think there's enough there, or in terms of emerging customary international law.
Let me just add one more piece to that. Something that hasn't come up yet. I'm a big believer in space traffic management being kept to civil activities, civil commercial activities, and not military activities. I think the way that is framed in the Chicago Convention for air traffic is the right way to do it. I think if you try to turn space traffic management into an arms control agreement, that's doomed for failure. So What I would like to see is sort of the space traffic management discussion focus on the normal civil commercial activities, and then probably a separate discussion on military interactions in space. And that may have, some different players involved in that. Something else we mentioned today is the Incidents at Sea Agreement, which was an agreement between the US and Soviet Union about how ships and aircraft interacted international airspace in the high seas, specifically to prevent something happening, a mistake or something happening that could serve as an escalation trigger. I think that is an excellent idea and would love to see a discussion between US, Russia, China, maybe a couple others on things like close approaches, military close approaches, intelligence activities, and a satellite testing. Now, of course, that's going to be very difficult. I think we've talked in other forums about how challenging it has been to build just some bilateral discussions between US and China and Russia and others. But I would just to kind of say, I think trying to lump all the national security and civil safety stuff together under the umbrella of space traffic management is probably not the approach I would recommend taking. I would kind of separate those two out.
I would support Brian's comment of that separation. I think that really is the way to go. And to come back to Professor Stevens, I think it really is a focus on definitions and also the building of iterations. So how do we don't have to solve everything. And what was mentioned before is we already have the building blocks. And so how do we slowly iterate that? But I do want to come back to, some of the research and what it points to when we have conversations with these different stakeholders. And if we're thinking about an STM system, it really has to be affordable, and there needs to be a very clear value proposition for participation, again, across the spectrum of levels of national space activities. We need to also be thinking about the technical capabilities that are necessary to participate in the system, and things like identification and tracking through the system. And also the STM system designs that really need to be inclusionary. So there needs to be a concerted effort to do our best in gaining consensus, but again, coming to the point of we can't wait for consensus, otherwise it's going to be too late. So how do we do both at the same time in parallel would be the best way to go.
So your point to coalition, I'll just address. We do this every day. We have great conversations between the CSPO partners, and those continued partnerships with space situational awareness sharing agreements continue to grow. I don't know. I'm sure we're signing a new one this week. We normally do at Space Symposium with. I don't know if you guys know there are 40 nations that are at Space Symposium this week. That's huge. That's the biggest number we've ever had. So that's very impressive to see that again. The number of countries who are interested in the space domain and what's going on and how to be involved, whether that be military, commercial, they're all in. But I do think there's a separation between, as a military member, day-to-day peacetime, and if you look at the air domain and others, we operate in conjunction with the civil authorities. When many of our Air Force bases, I always go to the air domain because that's where I spent 28 years of my career, is inside the Air Force, is that you have airports and Air Force bases sometimes sharing the same runways, and the rules and sets of how they talk to the tower and which tower they talk to and what they do every day. I mean, we know how to do that and operate in the space together. But then when we go downrange, we take our own air traffic controllers, we take our own capability, and we set up our own air responsibility, and we make that happen. That's the separation in the rule sets that I think we're talking about. I would also say the devil's going to be in the details, and as lawyers, you all know that. We talk when we get down to the specificity, so how close is too close? If I'm going to do rendezvous prox ops, or I'm going to do ISR, I'm going to do certain things, how close can two objects get together? I can tell you every day, we have 3 or 4 satellites that share a 1-degree block, and they do this, boom, boom, boom. They do block management, and they're back and forth, and they know each other, and they manage to station keep in the same area every day. Now, if one of those is a bad guy and a known threat capability, does that relationship change, and how does that go? And that's where this discussion goes to is the specificity piece of this. And each nation has a different look at this. And again, as technologies develop, so I'll go back to the air domain. We had this discussion with our allied partners on the panel and the next gen fusion leaders on Sunday. It used to be when you would fly an airplane, if you came off of the air traffic controllers network or you weren't squawking and talking to the tower, there usually was not a concern. They could see you on radar. There was, they would go, okay, they're probably having a problem, and they never thought anything nefarious. Well, after 9/11, that changed. And now we don't look at aircraft that stop squawking or their monitor turns off or their transponder turns off, something happens and they're not where they're supposed to be. Jets are scrambled, things are happening depending on where they're at when that occurs, right? So things are going to happen in our world that will change the specificity, and the technologies will evolve that will drive us to change those. So I think, again, having something and building and iterating over time as the domain develops and matures is going to be important. But I think we're all in as a coalition, and I've seen very supportive relationships. We're very tied. Headquarters Space Operations, Combined Space Operations Center, to the UK SPOC, the Canadian SPOC, and the OSPOC. We talk daily. They're in my briefs at the TSSCI level. We're talking threats, we're talking all those things. So again, and those continue to grow in those relationships. We're now working with France and Germany. How do we get to a NATO Space Operations Center? I mean, there's lots of things that are going to continue even on the military side to grow and into those rules and norms and rules of engagement, just like we see in every other domain on the military side. So I agree, there's probably two regimes here, but they will coexist and work together day to day.
So my apologies, I know we have more questions out there, but we are out of time. I want to thank Major Ken and our panelists for that absolutely fascinating conversation. It reminds me of something I talk to our cadets all the time about the need to have a baseline understanding of the technology in order to discuss the legal policy and strategy implications, which is why they all have to take astronautical engineering here at the Academy. So thank you very much.